Ms Harrison.
My lady, my lords, it now falls to me to address the court on the alternative submissions under issue 2 as to approach and under issue 3 as to the individual facts of the case. We have addressed issue 2 in our written case at paragraphs 42 to 50, that's EF 116 to 120, and in respect of issue 3, paragraphs 51 to 92, that's EF 120 to 138. Under issue 2, and whether or not the Court of Appeal adopted the correct approach in deciding whether an application to quash an asylum appeal determined under ultra vires structurally unfair and unjust rules, whether that was the correct approach, we make 5 points. The first point that we make, my lords and my lady, is that in order to establish whether in the individual case the structural unfairness in the rules was material, it is necessary only to consider the factors identified by the Court of Appeal in the detention action case by Lord Dyson, whether or not those factors apply in any individual case. It's not necessary to go beyond those factors. If they are present, we'll come on to what they are, then that is sufficient to demonstrate that the unfairness inherent within the rules impacted upon the individual appeal. I'm going to take as an example, because it's obviously germane to this case, a trafficking case as a paradigm example of the category of case in which the Court of Appeal in Detention Action 6 concluded not just that there was an unacceptable risk of unfairness, but there was inevitable unfairness. If that proposition is not correct, then at the very least we respectfully submit that in the alternative, those factors give rise to a presumption of unfairness in an individual appeal, and it is for the respondent to demonstrate to the contrary. Our third proposition, based upon the recent judgment in particular of this court in Pathan, but which we did identify already in our written case, is that the critical question in a case of factual or legal complexity of the kind like TN's is to ask the question whether or not the individual has lost an opportunity for a fair hearing in the application of those structurally unfair rules. And we will submit that in multiple ways the appellant was denied a fair opportunity to take steps that were necessary to pursue and advance her case. Finally, we say under issue 2 that the approach of the courts below, Mr. Justice Ouseley upheld by the Court of Appeal in the judgment of Lord Justice Singh, did in fact adopt an impermissible approach to approach, and in reality did require TN to discharge a burden to demonstrate that it would have made a difference to her case. They in effect applied a substantive prejudice case. They undertook an ex post facto counterfactual analysis of what would or would not have happened if she'd been decided under the principal rules, including by reference to what the appellant had done in the unfair process, and also what she did not do as the touchstone for deciding whether or not she had had an unfair appeal. We say that that approach is fundamentally contrary to the principles, some key of which you've heard this morning. And for those reasons, even if we're wrong in principle on our first or second approach, we say that the court itself, applying its own guidance, made a clear error of law. Under issue 3, we then say that TN's is a category of case that plainly falls within the category of case where the structural unfairness was present, that she plainly lost an opportunity not just to have her case determined under fair rules, i.e. the principal rules, but she also lost an opportunity in multiple ways to have a procedure in which she had sufficient opportunity to give instructions, which was critical in this case, to pursue and to investigate supporting material, and in particular, to give her an opportunity to displace adverse credibility findings that were made against her in the Secretary of State's refusal by obtaining independent expert or other supporting material. We do also ultimately say that even on the approach adopted by the Court of Appeal and asking the question of whether or not there was a causal link, there's only one answer, that there clearly was a causal link between the structural unfairness inherent within these rules and the determination of her case. So that's in broad terms how we put the case under issues 2 and 3. What I'm going to ask the court to do then now is to consider our first proposition, that in deciding whether or not in the individual case the structural unfairness has impacted upon it, it is only necessary to identify the category of case and the factors to be present that were identified by the Court of Appeal in the detention action case as giving rise to structural unfairness. It's critically important, we respectfully submit, to start from properly understanding what the significance was and the basis of the Court of Appeal's judgment in finding structural unfairness, because we do respectfully submit that the court below, particularly Lord Justice Singh's decision at paragraph 103(2), proceeded on the flawed basis that the underlying reason for concluding that the rules were structurally unfair was because they gave rise to an unacceptable risk of unfairness. Whereas in fact, we submit, when one looks at the judgment, it is quite clear, and I'll take the court to the relevant paragraphs, that their much higher threshold had been met here, because the court was satisfied that rather than there simply being an unacceptable risk of unfairness, there was a category of case, a significant number of cases in which unfairness was inevitable. And if you fall, we respectfully submit, into that category of case, then that's sufficient to demonstrate that your appeal is unfair and unlawful and therefore should be quashed. If I could then ask you to go back to the detention action judgment, and it's at Fourth Authorities 5, beginning at 2298, and to look at the paragraphs in which the court identified this category of case. And you'll see, first of all, in paragraph 38, that's at 2309, having set out the challenges pursuing the case under this system. Below letter F, you'll see that the conclusion of the court was that the timetable was such that it was inevitable in a significant number of appeals will be denied a fair hearing. So it's inevitability in the significant number of appeals. And then that similar approach was also adopted in paragraph 42. Below letter F, the period of 7 days between the date of the refusal decision and the hearing of the appeal is bound to be insufficient in a significant number of cases. And finally, in the court's key conclusion at paragraph 45 at 2311, first line, to summarize, in my view, the time limits are so tight as to make it impossible for there to be a fair hearing of appeals in a significant number of cases. And so we respectfully submit that the Court of Appeal in this case, proceeding as it did at paragraph 1032, on the basis that it was an unacceptable risk of unfairness in a significant number of cases, started from a wrong premise. Once it's found, as it was by the Court of Appeal, that there is a category of case in which it is impossible to have a fair hearing, or it's inevitable that you won't, or bound to be unfair, then we respectfully submit it's sufficient to identify those factors in that category of case, and if they're present, then the appeal must be accepted to be unfair and to be quashed. My Lord, Lord Panic showed you the... Oh, sorry.
Sorry, there's a question for you from Lord Stevens.
I was just perhaps jumping ahead, and I should restrain myself, I say that. But you say that there are multiple ways in which she was not given an opportunity, for instance, to give instructions or to displace adverse credibility findings. Whereabouts do I find the affidavit from her that says that she wasn't able to give instructions, or that she, if but only she had been given time, she would have been able to obtain evidence which would have displaced the credibility findings?
There is no specific affidavit evidence in respect of that, my Lord. We have relied upon the context in which the Court of Appeal accepted that in all cases there would be a difficulty in obtaining effective instructions, that being both the constraints on access to the individual because they're in detention, the limited time slots, for example, 45 minutes was all that was afforded, and the difficulties, therefore, of establishing trust with your lawyer, trust in the system. Those are features that are inherent within the process, and they are what one of the factors that the court identified in the detention action case as the starting point for why there would be an impossibility of carrying out very basic aspects of the task of properly presenting an individual.
But for all we know, she had trust in her lawyers and had an opportunity to discuss the case fully with them that she wished to make.
We know that from the sequence of events that she didn't have that opportunity because that situation didn't occur, because we know that she gave over time an increasingly enhanced account of experiences that she had had on her journey and once in the United Kingdom, and that we then know that account was more fully given in the context of a medical examination and in the context of an interview under the trafficking national referral mechanism. So there's no doubt that there was information that she had that she didn't provide at the time of the appeal, or it was provided in a very truncated, limited form. And we respectfully submit that in a context where the court has found that process, with its very limited opportunities to give instructions to establish trust, that one proceeds on the basis that impacted upon her case.
If I could just briefly return to credibility, her case is that in 2003, she and her mother were arrested in Vietnam and persecuted by the Vietnamese authorities. And also then in 2012, when she returned to Vietnam, she was arrested for the same reason, namely a difficulty in relation to money that had been collected for the church. If her mother died in 1990, then both of those, that evidence falls to the ground. And so how is she proposing to address the issue of credibility that her mother was alive in 2003, but died in 1990. She's had all the time since then to bring forward whatever evidence she wanted. And as far as I can see, there's absolutely none.
My Lord, there is a number of aspects of the credibility finding, adverse credibility finding, that is key to the reason why the detained fast track process didn't give her an adequate opportunity or a fair opportunity to support her case. In a situation such as this, where the individual's own testimony is inconsistent, implausible, lacking in credibility, it's critically important that that individual has an opportunity to obtain objective supporting material. In this context, the primary source of material is expert material, either from a medical practitioner or from country experts, or as in the context of trafficking, from trafficking experts. In the specific context of her claim relating to religious persecution, her case included, as you will have seen from her interview, the fact that she claimed to have been ill-treated in detention in Vietnam. There was material in the form of scarring that she identified on her body in the interview, where no steps were taken to obtain any supporting evidence in respect of that. The key material that could have been obtained but wasn't is available now, and that's in the report of the medical expert Dr. Bingham, who did document scarring on her body in a number of different forms that the doctor concluded was either consistent and overall highly consistent with her account of ill treatment in detention in Vietnam. In the context where the threshold for establishing a claim for asylum is the very low threshold of a real risk, real possibility, and that's applied to past facts as it is to future risk, that's the kind of evidence that does have impact on displacing adverse credibility findings. That's the material that the court in Detention Action 6 identified was not going to be able to be possible to obtain within the constraints of the timetable.
Thank you.
And ultimately, the adverse credibility findings that were made against her, we would accept, can only be displaced and addressed in circumstances where there's an explanation for why she may have given inconsistent, incomplete evidence, and that might be particularly in a context of trafficking, where you have been subject to influence of agents, you've been told to say things, you've been fearful in what you might say, and ultimately, again, that's going to require some form of medical evidence. Sorry.
Sorry, but she wasn't trafficked at the earlier stage. She was only trafficked at the later stage, and that's my difficulty I have. That she's given absolutely no explanation. There are lots of potential explanations that could be given, but she's given none that I've seen. And so when she returns in after the 2012 removal, she makes a case of trafficking at that stage. I didn't understand her making a case of being trafficked at the earlier stage.
My Lord, she does say that it was in when she first came here in 2003 and in 2014. But ultimately, the critical part of her case is the claim to have been ill-treated in detention as a result of attitudes towards her religion, and that, we respectfully submit, could only be addressed by reference to some form of independent material. And so when one is looking at credibility findings, it's critically important to recognise and it's extremely commonplace, as I'm sure those with an experience in the asylum field. You have to have independent supporting material, and that was an important aspect of why the detained fast track process, with its 6-day time limit, operated unfairly, because there simply wasn't sufficient time to obtain that kind of material. And that is evident from paragraph 19 of the judgment of Lord Dyson. He says in terms, the highly expedited timetable and the fact that the appellant is in detention, which makes the task of obtaining corroborative evidence, particularly relating to credibility, very difficult. Obviously, that's jumping ahead to issue 3, and I appreciate why your Lord wants to put to me where you get to on issue 3, but if I could just go back to issue 2 and to say why those factors should lead to a situation where it's accepted that the structural unfairness impacted upon the individual decision. In addition to the limits on the ability to obtain instructions in detention and in the limited time frame available, the problem of obtaining independent material and sufficient time to carry out those investigations are the key factors we respectfully submit where the unfairness in the general system impacted upon the individual case. And we do submit that there's nothing surprising about that. It's important to recognise that the fast track process was only supposed to be limited to cases that were straightforward and suitable for a quick decision. And it had already been the case from the outset that the Secretary of State had indicated that cases that were complex or required expert evidence, including to displace adverse credibility findings, or where there were medical problems, were categories of case that should not be in this process at all. And if I could ask the court to take up the Refugee Legal Centre case, which is in Core Authorities tab 12 at 2601, you'll see how that was supposed to be integral to this process. And it's in paragraph 12, where in seeking to persuade the Court of Appeal that there was flexibility within this system and safeguards when it was first introduced way back in 2004, the Secretary of State's witness gave evidence about the flexibility in the system and identified the categories of case that were not suitable at all for the detained fast track. It's where they were particularly complex or require expert evidence or who have medical problems. They are removed from the system. So that was what was intended to be the case. And you'll see that also from the Secretary of State's own policy, which is in volume 2, tab 25, and that's EF 2869. So it's the detained fast track processes, and the criteria for inclusion within the process is at 2869 under the heading Quick Decisions. The assessment of whether a quick decision is likely in a case must be made based on the facts raised in an individual case. Cases where a quick decision may be possible may include, but are not limited to, where it appears likely that no further inquiries by the Home Office or the applicant are necessary in order to obtain clarification complex legal advice, or corroborative evidence, which is material to the consideration of the claim, or where it appears likely that any such inquiries can be conducted to allow a decision to take place within normal timescales. So clearly, where there was a need for further inquiries or to obtain clarification, complex legal advice, or corroborative evidence, then that category of case was never intended to be within the detained fast track at all, and it was part of the structural problems leading to the unfairness in the system those categories of case were simply not removed from it, and that ultimately was recognised by the Secretary of State herself when she suspended the detained fast track in July 2015. And if I could just ask the court to look at the order in the case, which is the case of JM, it's in Appendix 2C, page 1080. And it's a consent order which we'll see was approved by Mr. Justice Blake, but it was accepted in July 2015. The detained fast track process itself overall had been operating with unacceptable risk of unfairness for categories of vulnerable or potentially vulnerable individuals. And the reason for that unacceptable failure was to do with the identification of such individuals, and even when such individuals were identified, to recognise that those cases that required further investigation, in some cases clinical investigation, this created an unacceptable risk of failure to identify those whose claims were unsuitable for quick decisions within the DFT. And the reasons for that order were given paragraphs 47 to 50. That's at 1091. And it was because the unacceptable risk of unfairness for vulnerable or potentially vulnerable claims, the safeguards were not operating effectively to identify, remove those individuals. And in particular at 49, cases where further investigation into their claims of torture, oral treatment, or other vulnerability cannot be obtained in detention. So the proposition that we make about the significance of those categories of the category of complex case that required further inquiry and investigation, that required objective supporting material, including to displace adverse credibility findings. Those are the category of case that should not have been in the system at all. And if they were, it is clear from the judgment of the Court of Appeal, Lord Dyson's judgment at 45, it is impossible in a significant number of those cases for a fair hearing to take place. And so rather than the approach of the Court of Appeal and Mr. Justice Ousley in this case, which was to require something over and above the fact that the case was determined within these structurally unfair rules, we say that in that category of case identified as being one where it was inevitable that unfairness would arise because you wouldn't have sufficient opportunity to prepare or present your case, then we respectfully submit that is a case in which the unfairness has materialised on the individual facts, and the individual has been subject to the procedural disadvantages that rendered the system unlawful overall. We do say that in that context of identifying categories of case in which it was inevitable, that the unfairness would bite. A trafficking case is the paradigm case. And when we refer to, in our case as we do, to potential trafficking victims, can I just clarify, because it's a point that the Secretary of State takes, potential trafficking victim can mean two things in this context. It can mean a case where there is a reasonable grounds decision, but it can also be, and it's in this context that we refer to potential trafficking, is in the context where there are indicators, so a prior situation that triggers the investigative duty. In a case of before the Court of Appeal TDT, which I'll take you to shortly, the caveat was added: potential trafficking victims, i.e. it's possible that you are a victim of trafficking without having yet established a reasonable grounds decision. And it's in that context that Mr. Justice Ousley and the orders that I've shown the court in JM were considering, were treating potential victims. It's possible. There are indicators rather than having reached yet the reasonable grounds threshold. But we respectfully submit that in the context of trafficking, there is in fact a magnification or a compounding of the unfairness that was inherent within the process itself. And we say that for a number of reasons. And it does go back, first of all, to the aspects of the case that resulted in the ruling in detention action, starting with the limited opportunity to take instructions and to build trust, because that challenge is intensified in circumstances where you have a potential victim of trafficking who may have experienced trauma, ill treatment, sexual exploitation. There are many factors that make disclosure of a case in a timely and consistent and coherent manner very much more challenging. And where it is well established, and I'll show you the Secretary of State's own policy, that self-disclosure or self-identification does depend upon not just a relationship of trust with the lawyer, but also in the system. And we do say that the observations of Lord Reid in Osborne have particular resonance in a context where you have individuals who it's well recognised may be at risk of re-trafficking, fear reprisal from traffickers if they disclose information. They in particular need to be confident in the system delivering them justice so that they can place their trust in it, given the adverse consequences were a wrong decision to be taken. It obviously also illustrates why procedural fairness is a human right, because of the individual's dependence on that process to deliver them protection if they need it, and why a procedurally unfair system obviously runs the risk of exposing a person to irredeemable harm. The importance of objective indicators, therefore, is particularly important in circumstances where you cannot rely on the individual to self-identify and to give a full and coherent and detailed account from the outset. There is substantial evidence, both in our case and in the intervener's case, that emphasises the importance of trust in the system. If I can show you one piece of evidence and then take you to the Secretary of State's own policy, there was a witness statement from Miss Wendy Hewitt, who's the Legal and Policy Officer of the Equality and Human Rights Commission. That witness statement is in EF 1045 at paragraph 82. And that's in Appendix Part 2C. and the particular paragraph is at 1070. At paragraph 82, it begins on 1069 under the heading Victims of Trafficking. And if I could ask the court to read paragraph 82, it gives a overlying summary of why victims of trafficking have particular needs for an appropriate environment in which to establish trust to disclose their claim. The Secretary of State's policy in respect of guidance given to its frontline officers who have responsibility for identifying potential victims of trafficking. That document is in Authorities Volume 3, beginning in tab 29. Sorry, if I could ask you first of all to look at tab 30. And this is guidance that is given to all.
The bundle number, please.
Oh, sorry, my lord. It is 3186.
Thank you.
You'll see on 3187 how it's guidance to frontline staff on how to identify and help potential victims of trafficking. There's a helpful definition of trafficking at 3190, which includes the transfer of persons under forms of coercion who are in a position of vulnerability and for the purposes of exploitation. You'll see below that human trafficking is essentially recruitment, movement or receipt of a person by deception or coercion into a situation of exploitation. So within the very experience of trafficking is exploitation, coercion, which will have clearly adverse impacts on an individual's psychological state, which also have to be factored into account. You'll see at 3201, it's recognised that the applicant may not identify themselves as a victim of trafficking for a number of reasons. Those reasons include some of those that I've already given: fear of reprisal, fear of removal, the situation of dependency in which they may find themselves.
The reference again, please, Ms. Harrison.
Sorry, my lord. It is at 3202.
Thank you.
It means that it's necessary to give very specific and more detailed guidance on how one obtains information from potential victims of trafficking. You'll see the guidance that's given at 3205 to 3206. And in particular on 3206, if you're interviewing a victim of sexual assault, the sorts of factors that have to be taken into account when carrying out an interview in that context, because you're having to recognize that there may be fear, loss of self-confidence, self-esteem, difficulty in concentration, self-blame, shame, pervasive loss of control, etc. And importantly, in that context, you must not automatically draw negative assumptions. If a woman cannot recount details of their experience when you assess their credibility, etc. So a recognition that those factors are going to impact on the accounts that are given. Again at 3210, trafficking women being at risk of reprisal from trafficking rings, discrimination, and the risk of being re-trafficked. Because of the inhibitions and barriers to self-identification and disclosure, the guidance looks to identify objective indicators of trafficking and sets out in some detail what they are, beginning at 3216, all of which can lead to the triggering of the investigative duty, irrespective of the individual's individual accounts and whether or not they themselves have self-identified as a victim of trafficking. And you'll see at 3216, it goes in some detail to physical indicators of trafficking, injuries, sexual health indicators, pregnancy as a result of the trafficking situation. Over the page at 3217, psychological indicators, expression of fear, depression, recalling dates or entire episodes and difficulty concentrating. And then at 3218, distrust of authorities, acting on the instructions of another, fearful and emotional, limited English, someone's taken advantage of their legal status. And then 3219, a bringing together of the obstacles that inhibit victims coming forward, some of which are repetitive of what we heard before, but it's a risk of punishment, accused of being complicit in illegal activity, reprisal. They are in a situation of dependency, in extreme circumstances, obviously Stockholm syndrome, and they may blame themselves. It is for this reason that you see at 3220 that the burden is upon the Home Office, the authority, to verify if a person is a victim of trafficking. And at this third paragraph down, if they will not identify themselves as a victim, you must consider if there are any objective signs. Such indicators help you identify potential victims of trafficking. It is important you do not rely on victims to identify themselves, but instead know how to recognize and identify the signs of trafficking. So the burden very much on the authority to identify indicators. And of course, in that context, where you do have a complex and challenging task to identify from an account that a potential victim of trafficking is given, what is true, what is not true, what is arising because of influence from others or fear of reprisal, all of those combination of factors, clearly working out what has happened in the past and doing that on the basis of a real risk. So ultimately not having to determine the truth of something, but whether it's a possibility, a serious possibility that these events have occurred. One can see how, albeit if one wants to identify an aspect of the case, as my Lord Stevens does, there's no answer to this. Actually, that isn't the way with respect to look at the complicated assessment that has to be undertaken of credibility, veracity, and risk in these highly vulnerable individuals who have experienced often multiple trauma and multiple factors that seriously inhibit their ability to give what one would normally expect in terms of a consistent and coherent account. And it's for that reason that at this stage as well, we're not concerned even with the real possibility threshold. That's the ultimate threshold. But in order to identify whether this person's account triggers the investigative duty, it is simply necessary to ask, is there a suspicion or a claim? And my Lord, I did indicate I was going to take you to the judgment of the Court of Appeal in the case of TDT. If I could ask you to do that now, it's in core volume. Sorry. at EF 2611. At tab 13. Where the Court of Appeal has given to date its most authoritative guidance on the investigative duty in the judgment of Lord Justice Underhill. And if the court can turn to paragraph 33, beginning at paragraph 30 perhaps, it's on 2623. First of all, citing a judgment of Mr. Justice Burnett, as he then was, in a case called Hang. And you'll see, if you then go to paragraph 31 under little 2, what kind of threshold we're here concerned with, and what's described as the very low threshold. Credible suspicion, which calls for investigation. And you'll see at paragraph 33 a summary of the obligations in identifying indicators of trafficking in order then to trigger those investigative and protective duties under little 1. And it's at paragraph 34 that you see the distinction between potential victims and what then Lord Justice Underhill described as potential victims of trafficking, in order to make the distinction between the two, even though invariably they're both referred to as potential. We're in the double potential category, if that in terms of this particular case and what happened to her in the context of the detained fast track. In the judgment, the court had to consider the interrelationship between a past history of trafficking and future risk. And you'll see at paragraph 39, under letter H, it's prudent to regard any past victim of trafficking as a potential victim of re-trafficking, and is important for the duty to be engaged so that an assessment of that risk can be made if on such an assessment a reasonable view is taken that there is no longer any risk requiring protective measure. The duties would be readily discharged. You'll see at paragraph 40 that in applying that to a particular context, the court did include as classic victims of trafficking, potential victims of trafficking, those who are working in a cannabis farm or a nail bar, who will have been trafficked in the preceding period, but will be at real and immediate risk of trafficking continuing. And so it's in that context that one can see that that risk of re-trafficking is also a feature that plays out in terms of an individual's position when going through the detained fast track. One other important issue that the court had to decide was the significance of generic or specific evidence. And the court held at paragraph 47, this is at 2628, that falling within a particular class of person peculiarly vulnerable to being trafficked could be sufficient to cross the threshold of credible suspicion. Again, the emphasis being not on the account of the individual, but upon the objective evidence indicating that the person may be a victim of trafficking. And in order to demonstrate that you fall within such a class, it's important to have generic evidence. And the court can see that at paragraph 57 at 2631, the kinds of material that is required to demonstrate that one is falling within that category of case or within the class of case. That's 57. And on the particular facts of the case, the Court of Appeal concluded that that individual did fall within that class, didn't need therefore to depend upon his account, so that's at 78, or solely upon his account, at paragraph 78 to 80. And if the court can read those two paragraphs, but again, emphasis on the extensive supporting material that was available in that particular case, and which, in my respectful submission, confirms two things about trafficking cases over and above the difficulty of obtaining information from individuals. One does need to have access to supporting material, particularly in cases where one cannot rely upon the account that the individual themselves has given, or indeed may not even have given an account at all. So that's why we say, in the context of the factors identified by the Court of Appeal in the detention action case, is it a complex case? Did it require more time for instructions to be given and an opportunity to obtain evidence that could displace adverse credibility findings? We respectfully submit that it's plain that in a trafficking context, those difficulties are amplified substantially. And that combination of factors, which undoubtedly arose in TN's case, we respectfully submit was a basis upon which the court should have, if it have concluded that that was sufficient to demonstrate unfairness in our individual case. If we are wrong about that, then we respectfully submit that the alternative proposition that we put, but which was rejected by the Court of Appeal below, that there is a presumption of unfairness, should have been accepted. That was rejected by Mr. Justice Ousley at paragraph 114, that's EF 255, and by the Court of Appeal at paragraph 97, EF 211, Court of Appeal proceeding upon the basis that there was no presumption either way, that essentially you started on a level playing field with no presumption either way. We say that that was fundamentally wrong approach. We say that because, first and foremost, under the principal rules, it was for the Secretary of State who had to justify subjecting the individual to the abbreviated time frame of the detained fast track. And of course, it is in a detention context where the Secretary of State also has a heavy duty of justification to justify depriving an individual of their liberty. We would also pray in aid the point made by my Lord Panic this morning about the significance of the fact that it is the Secretary of State, the executive, who imposed the constraints of the DFT on individual cases and subject them in effect to the serious procedural disadvantages that the court in the detention action case identified. So not only was it the executive that subjected the case to that disadvantage, by corollary, the Secretary of State also had procedural advantage from the fact that the person was in the abbreviated time frame and with limited case management powers. That, we respectfully submit, points strongly in favour of a presumption of unfairness in a complex and difficult case, falling within the categories that I've identified. And it should also follow from some of the key principles that we heard this morning about the value to which the court places upon procedural fairness as an aspect of the rule of law, and in showing that not only is justice done, that it's seen to be done. it also has the effect, if we don't start from any presumption, that the finding, and obviously crossing the high threshold for structural unfairness, had no implication whatsoever for individual cases. So in fact, reversing the ordinary principle that it would only ever be in very exceptional cases that a procedurally unfair decision could stand. And so for these reasons, we respectfully submit that the Court of Appeal was wrong to reject our submission that in a category of case falling within that identified by the Court of Appeal in Detention Action 6 as giving rise to inevitable unfairness, that presumption should be in place, and it should be the Secretary of State who has the burden to demonstrate to the contrary. It certainly wasn't something that was rejected by Mr. Justice Ousley in paragraph 114 at EF 255. He did say that the Secretary of State may be able to show no unfairness in reality. So Mr. Justice Ousley did not proceed upon the basis that it would be impossible or impracticable for the Secretary of State to have that burden.
But is this realistic? Because I'm just trying to track it through. Suppose that you have a case like the present one, and it's challenged on the basis that the trial must have been unfair. So you put the Secretary of State in the position whereby there is a presumption that the hearing was unfair because of the factors in DA 6. But then the Secretary of State will say, but at the hearing, the applicant was able to place before the FTT all the points and arguments which the applicant had, and we're not aware of anything else. And then the burden will shift back, surely, to the applicant to say, oh, no, I needed to put in evidence about a medical report, about my medical condition, and I simply hadn't had time and I didn't know what my position was. So that at the end of the day, it doesn't make much difference, is it, where the presumption is. You're still going to have to go into the same granular issues if the automaticity doesn't apply, so that the presumption serves little purpose.
Well, in my respectful submission, it would serve the purpose of giving effect to the judgment that the structural that the rules are structurally unfair in identified categories of case. So it gives effect to that very important finding that the rules are contrary to what Parliament intended. The corollary is that there's no consequence of the whole system being unfair. And of course, it would require in the first place for the individual to identify that they fall within the category of complex case, requiring further time, or to obtain supporting evidence to displace adverse credibility findings. You would have to do that. And it's in those circumstances that we say that there is a presumption that the Secretary of State should have the burden to show some other kind of exceptional factor that took it out of the cases affected by inherent unfairness. Turning then to the third way in which we say that the Court of Appeal was wrong in principle in its approach, and that does turn on considering the court's recent judgment in Pathan, which you have looked at this morning. But if I could just identify some additional paragraphs, but essentially what we say is that the Court of Appeal and Mr. Justice Ousley did not apply the correct approach in asking the question, did the applicant have a fair opportunity to present and pursue her case, including to pursue alternative courses of action in obtaining material, for example. That's not the approach that the court took. It took an approach of analysing what the individual did within the constraints of the detained fast track process and extrapolated from that what it might do in the future. It didn't adopt an opportunity approach, and it was very much focusing on outcome rather than on the impact of the procedural disadvantages. If I can ask you to go back to the Pathan judgment in core authorities, tab 10 at 2471. And in particular, to go back to paragraph 132 at 2514. And to emphasise that the court there made clear in the judgment of Lady Black and Lord Kerr, reflecting the majority, that it does not rest on any estimate of any likely success in pursuing any of the chances that opened up for him. That's at paragraph 132. To emphasise at 133 on 2514 that the impossibility of knowing now what would have happened had Mr. Pathan had the additional time that a timely notification would have afforded to him, and why asking those questions wouldn't be appropriate under procedural fairness ground. 134, which Lord Panic did take you to, but which we emphasise because we say that's precisely what the Court of Appeal and Mr. Justice Ouseley did, which is to carry out an ex post facto assessment. And at 135, emphasising that to deny the person the greater opportunity to avoid consequences was itself unfair, and that did not depend on any judgment as to whether he would have sought to avoid that outcome, whether he would or not to deprive him of the chance was unfair. That's critically important in clarifying the correct approach to a procedural unfairness case, because even in that context, the individual wouldn't have to demonstrate that they would have taken the option, but simply that there were other options that could have improved their position in respect of the decision maker. And that's emphasised at 136 in the about 5 lines up from the bottom. In principle, it can be just as unfair procedurally to restrict a person's opportunity to take steps to avoid the effect of the decision as it would be to deny him the opportunity to make representations. And finally, at 138, it's both the opportunity to make representations, whether or not that opportunity is availed of. And applying that approach to the context of this case, clearly both aspects of procedural unfairness were in play. One, an opportunity to advance a case, to obtain material, and also an opportunity to take alternative steps to support the case. Clearly, the gravity of issues in TN's case are more serious than they were in Mr. Pathan's case in terms of impact of a wrong decision. And we say that it's clear when one considers the judgments below, in particular paragraph 142 of Mr. Justice Ouseley's judgment that was upheld by the Court of Appeal, paragraph 97, that he did adopt an impermissible approach. If you go to that paragraph at 142, it's at EF 262. He didn't ask himself whether TN had lost an opportunity. Instead, he came to speculative conclusions about whether the evidence would have been obtainable, would it have come in a particular time frame of the principal rules, whether there was any evidence that she would have presented a completely different claim if only she had had more time in which to produce medical evidence. There's no reason to suppose the evidence would have been relevant to whether her claim was credible. No reason to think it would have been obtained in the time frame of the principal rules. And then went on to consider the timing of what she actually did in terms of obtaining supporting evidence, which was again the approach that was adopted by the Court of Appeal, Lord Justice Singh, at paragraph 99, EF 21, with Mr. Justice Ousley, and in particular the Court of Appeal, focusing ultimately on the end result, as opposed to whether or not the unfair procedure rules denied TN of an opportunity to take steps that could have displaced the adverse credibility findings in particular. And obviously, it's evident from the submissions that we've already made as to what that sort of material could have been. More time to give instructions, to establish trust, more time to follow up investigations, to obtain supporting evidence, whether that's objective country material, medical evidence, which was likely and is crucial, in order to displace those adverse reasons that the Secretary of State had given. The fact of the matter is, in this case, we do know that that material was available. What she's criticised for is the timing of which she obtained it. But in my respectful submission, properly applying the approach in Pathan, that's irrelevant to the question. It's absolutely plain that she had been denied the opportunity to obtain material that could have resulted in her being able to address the Secretary of State's refusal. And indeed, we do respectfully submit that that's made absolutely apparent, ultimately by Mr. Justice Ousley's conclusion on the medical evidence. That's at paragraph 147, EF 263, because in considering the fresh claim decision, Mr. Justice Ousley did come to the conclusion that having the benefit of Dr. Bingham's report did mean that the earlier refusal of her case under the fast track rules now could have real prospects of a different outcome. So although we don't need it, properly applying the approach in the Pathan case, this is a situation where we do in fact have evidence that demonstrates that lost opportunity could result in a different outcome. And of course, we know that even weak cases that are entitled to procedural fairness, and on no view, we respectfully submit, even if one can identify an aspect of her case in which one cannot contemplate a different outcome, the death of the mother, the overall claim, there is no sensible basis on which to conclude that that in a fair process, she couldn't have obtained material that was capable of displacing the adverse credibility findings. For those reasons, then, we say we succeed on issue 2, but if we don't, going over to issue 3 and looking...
Before you do, could I just ask you a question?
Yes, of course.
If obviously this case is immensely important to your client, I don't suggest that I don't think that, but just looking at these opportunities that she was denied, you gave us a list which was quite abstract in general, if I may say so. Then you gave us a specific example of Dr. Bingham's report. Can
Yes.
you give us, I mean, it seems to me very important that you should concretize it. Just for my note, tell me what
Yes.
other specific opportunities she missed out on.
Yes, if I can do that now, that's what I was
Thank
going
you.
to turn to. So in terms of objective evidence, supporting her account of religious persecution, there was material that was available. If I can give you the references, in the witness statement of Ms. Payne at EF 92 is summarised in the statements of facts and issues at 88 to 91. She draws together and gives detail and analysis of objective material that supports both her claim for religious persecution and extensive indicators of trafficking that were available on the evidence to the Secretary of State. So although she's providing a witness statement that draws together on the basis of her expertise what those indicators were, it's important to note that they are based upon the material that was available at the time. But her expertise in drawing them together is the sort of material that could have been obtained. It's the sort of material that the Court of Appeal placed reliance on in the TDT case.
I do apologise. What does Ms. Callaway Payne actually say about religious persecution?
My Lord, she makes reference to material that was available, including the Secretary of State's own guidance that showed that there was persecution of Catholics in Vietnam. So it's objective confirmation that there is persecutory action taken against those who are linked to this religion.
Well, not necessarily now, but at some stage, could I have the page reference for that?
Yes, my Lord. I'll give you that now, my Lord. It's at page EF 1121, paragraph 19.
Yeah, thank you very much indeed. Okay.
And then her report in very extensive detail, which we summarised the key parts in the statement of facts and issues, sets out the multiple indicators of trafficking that there were in her case. So that's objective country information. There is, we submit, the importance of medical evidence, and that medical evidence had multiple ways in which it was supportive of her case. If I could ask you to look at the medical report from Dr. Bingham. It is summarised in the Statement of Facts and Issues at 77 onwards at EF 91. But if I can ask you to take it up, it's in volume 2B at EF 880. And one should note from the outset that this doctor is a specialist doctor from the Medical Foundation, from Medical Justice. She had a 2-hour interview with TN. You'll see that at paragraph 74, page 885. But what she did is to do a detailed medical examination of the scarring on TN's body, which she sets out at 884, paragraph 667. She also undertook a detailed mental state examination. That's at 885 to 886. She does give some indication about her ability to disclose information at 74. And then she made detailed findings applying her clinical expertise. And you'll see what those findings are at 886 in respect of the scarring. So she assessed, applying the recognised approach of the Istanbul Protocol, each individual scar to determine whether they were consistent or highly consistent with the account that was given. And then came to an overall conclusion, which you'll see at the bottom, paragraph 92, that the pattern of scarring overall is highly consistent with the history of beatings and rapes described. And that includes the account of beatings in detention in Vietnam, which is obviously related to the claim based on religious persecution. So she's looked at the overall presentation of those scars, and she's come to a conclusion that they're highly consistent. That is of significance because we know from the decision of this court in the case of KV that conclusions such as that are capable of supporting an individual's account. And of course, the Secretary of State had put in issue and disputed that the injuries that she identified in the in her interview were in any way related to or could be attributed to her account of ill treatment. So the doctor's evidence was important in a number of respects in terms of both aspects of her account, but then in terms of the mental state, the doctor goes on to make a diagnosis of PTSD, that's at paragraph 94, and to give some of the ways in which that medical condition was impacting upon her at 95, including flashbacks, re-traumatization, disassociation, and which the doctor concludes would have an impact on her ability to disclose details. In particular, you see at 100, she says the importance of gradually building a rapport in the assessment. Initial hesitancy suggested it was difficult for her to disclose her history. This would be expected to cause her difficulty in the formal interview, brief assessments, including presenting for healthcare. Additional time and additional support should be allocated. The doctor did make an assessment in accordance with her expertise about whether the claim was fabricated or exaggerated and came to the conclusion that it was not. Her overall conclusion, therefore, was that her account of past events that was a presentation, is highly consistent with a history of trafficking, imprisonment, multiple rapes, and forced prostitution. So the report was capable both of supporting her account, displacing adverse credibility findings, but also giving some explanation for why it was that there had been delay in disclosure, incomplete disclosure, and other factors. So that medical evidence was critically important. The Secretary of State, in response, says, well, no application for an adjournment was made in order to obtain this kind of evidence. We respectfully submit that that response goes directly behind the reasoning of the Court of Appeal in the detention action case. As my Lord Panic explained this morning on the basis of the judgment, the court rejected the power to adjourn as an adequate remedy because it was limited to 10 days and it would not have allowed a medical report of the kind that Dr. Bingham undertook to have been obtained ordinarily. We make reference in our case to the fact that up to 5 months is often allowed for medical reports of this kind to be obtained. The reference for that is Authorities 25 EF 2845. And again, transfer out, as we've seen, was not an effective safeguard that would have permitted this evidence to be obtained within those abbreviated timeframes. And so that clearly is, we respectfully submit, powerful evidence that the structural unfairness did deprive TN of a fair opportunity to present her case, to pursue alternative sources of material, and to have a real chance of displacing the Secretary of State's adverse credibility findings. The other matter, of course, that the Secretary of State relies upon is the fact that TN herself withdrew from consideration the rape and ill treatment on her journey. We say two things about that. First and foremost, the fact that an individual who may be a victim of trafficking withdraws part of that claim from consideration by the tribunal is not an indication that that process was operating fairly. It must be a matter of real concern that those disadvantages that were identified in the process by the Court of Appeal in Detention Action in fact had the logical conclusion that an individual withdrew a case rather than have it rejected. And obviously that evidence that I've shown you from the Secretary of State's own policy about fear of reprisal, risk of re-trafficking, if you are not given protection, has to come into play. So we respectfully submit, rather than being the end to her case in terms of procedural fairness, it goes to underscore why in this particular case that procedural unfairness not only had the impact of disadvantaging her, it led to, or at least one cannot exclude it leading to the fact that that part of a claim was never investigated by either the Secretary of State or the police or the first tier tribunal, so that the authorities have failed to act upon the numerous objective indicators that were available, and that trafficking claim was not at all investigated before the adverse conclusion of the FTT. And again, that is obviously an important adverse loss of opportunity that occurred. She didn't have the relevant authorities investigate those matters, whether that be the Home Office or the police, who would have the duty to do so. For those reasons, we respectfully submit that this is a case in which all of the factors, sorry, I think Lord Stevens.
Sorry, I do apologize, but if you go to page 880 of the electronic bundle, you'll see that Dr. Bingham had one of the documents that she'd read was the number 2, the appeal determination of the 22nd of August 2014, which is the first tier tribunal decision, which in short form said that the only thing they believed was her nationality and her name.
Yes.
And then at page 881, the background history is related by the applicant, the appellant. But nowhere in this report that I can see do they engage with. Does Dr. Bingham challenge or inquire or ask, you know, is any of this true? She comes to a conclusion that's not fabricated, but I'm not quite sure how she arrives at that conclusion.
She does that by applying the recognized protocol for assessment of victims of torture or other ill treatment. All that she can do as an expert is to assess whether there are clinically significant factors, whether they're physical scarring or psychological indicators of trauma that are consistent with the account that is given.
I always thought that,
or there's a sliding scale, or highly consistent or typical of. And the importance of that material is that it is capable of supporting the account, because it identifies correlation between the clinically significant indicators and the account that is given. And there was a recent judgment of the Supreme Court in KV, which is at tab 5 to 41. I could just ask, sorry, volume 5, 41.
What page is that, please?
And the page is at 3757.
Thank you.
It was a case in which the individual's account had been roundly rejected or was on credibility grounds. You'll see that at paragraph 8. But there was medical evidence about the injuries that this man had on his body. They were stark injuries. They were burning on his back. But the court gave general guidance on the significance of a doctor being able to correlate injuries with an account that's given. And your lordships, if I could ask you to note and to read paragraph 20 to 22. So this court confirming how important such medical evidence can be. In terms of the proposition that my Lord Stevens put to me about truth, that isn't the task of the doctor. You'll see that at paragraph C to D on page 3766. Sorry, in paragraph 25, C to D. And in part, the answer that was given by Lord Wilson is, you'll see just above D, in an asylum case in which the question is only whether there is a real possibility that the account given is true, not even the decision maker is required to arrive at an overall belief in its truth. The inquiry is into credibility only of a partial character. And so obviously it's important that when one has material like Dr. Bingham's report, it's going to go into an evaluation ultimately determined on the basis of a real possibility. And that's why often in these categories of case, medical evidence is decisive. It's also the reason why ultimately Mr. Justice Ousley concluded that that medical evidence meant that there was a real prospect of a different outcome from the one that had occurred under the detained fast track process. And obviously one cannot place the determination against the medical evidence, because that determination was critically made without the benefit of any supporting medical evidence. And that's obviously one of the key ways in which we say, not only does that bring TN's case within the category of case where Lord Dyson identified inevitable unfairness, it also demonstrates quite clearly why she lost an important and valuable opportunity to obtain supporting material that could have displaced the critical adverse credibility findings, and why we respectfully submit, contrary to the judgment of the Court of Appeal, this was a case of unfairness. And we should just finally emphasise, in coming to its conclusions about procedural unfairness, we do submit that nowhere does the Court of Appeal analyse the case in the context of lost opportunity to take steps. We do submit that it did in fact consider and require substantive prejudice. It did carry out an ex post facto analysis based on what she did and didn't do, critically, first of all, under the unfair process, and then subsequently having been subject to the unfair procedure. And that approach cannot stand as consistent with this court's recent judgment in the case of Pathan. And for these reasons, my lords, my lady, we would ask you on individuals' TN facts to conclude that this was an example of the structural unfairness and injustice in the system, materially and adversely impacting on an individual case.
Thank you, Ms. Harrison. Scaroy.
My Lady, my Lords, I appear on behalf of Detention Action and the Helen Bamber Foundation as joint interveners. And I hope that you have seen our written submissions, which I rely on in full. They are at supplementary bundle, electronic folder, pages 58 to 87. And as you will have seen from the introduction to those submissions, both interveners have extensive experience, both of the fast track process and of the relevant underlying litigation. I agree on and adopt on their behalf the appellant's submissions on ground 1 and ground 2. And in particular, I agree that each and every appeal heard under the structurally unfair and unjust rules was determined unfairly for the reasons Lord Panic outlined this morning. In my submissions, I want to spend a little time looking at exactly why the courts in DA6 and DA5, as I'm going to call them, that's the Court of Appeals judgment and Mr. Justice Nichols' judgment, reached the conclusions they did about the fast track rules and what exactly it was that they found. And that's important in my submission because in TN, both the Court of Appeal and the High Court suggested that it was possible that a majority of appeals may have been fairly decided under those rules. In my submission, when those judgments are properly understood, it is clear that the features of the system which made it structurally unfair also made the process unfair for each and every case. My Lords, my Lady, the starting point is that asylum appeals are, as the Court of Appeal said at paragraph 27 of DA6, full adversarial hearings intended to hear oral witness evidence from the Secretary of State and the appellant on all issues before it and make fresh findings of fact, including on evidence and matters arising which were not before the decision maker. Now, the issues which are in dispute and the matters on which evidence is required become apparent on receipt of the Home Secretary's decision letter refusing asylum. And very often, as in this case, TN's case, this letter, and that letter is in the electronic folder at 769 to 781 for your note, and it's summarised in the Statement of Facts and Issues at paragraph 50, which is at pages 84 to 85. Very often, this letter will include adverse credibility findings, which a successful appeal will have to displace. And in practice, therefore, as the Court of Appeal recognised in that same paragraph, paragraph 27 in DA6, it's likely that the only way to displace such findings on appeal is to produce corroborative evidence to support the account, whether specific to the individual or relating to the country of origin. Despite that, under the fast track rules 2005 and 2014, but under the 2005 version, the appeal was listed within 6 working days of that refusal letter. The standard timetable is 6 weeks. Now, or was 6 weeks. Now, you were shown this morning the table in DA6, which was the comparator between the 2014 rules and the principal rules. In our submissions at supplementary folder 67 to 68, there is an equivalent table for the 2005 rules to the 2000 and the principal rules then in place. And you
Where do we find that? Where do we find that?
If you turn to supplementary folder 67 to 68, you'll see the table there.
Thank you.
So the starting point is that the ordinary timetable is 6 weeks, and these appellants had 6 working days. The second key feature of these appeals is that the appellants were always detained. Now, it goes without saying that detention, combined with accelerated timescales, constitutes a serious impediment to preparing any appeal. The third key feature of this scheme was that the allocation, and you heard this morning from Lord Panic, of the 6-day timetable was based on a decision by the defendant to detain the appellant in a particular detention centre. And the fourth key feature is that the first tier tribunal itself did not at any stage consider whether 6 days afforded the appellant a fair opportunity to prepare the appeal. And the final feature is that despite all of that, despite the extreme brevity of the process and the fact that the first tier tribunal never considered whether it was fair in an individual case, once you were in it, there was, to use the words of Mr. Justice Ousley, and that's paragraph 87 of his judgment for your note, a strong bias or presumption against coming out of it. And to use the words of the Home Secretary at the time, Theresa May MP, there was a burden on the appellant to show exceptional circumstances. And her letter, describing it that way, is in the supplementary folder at pages 101 to 102. Now, in my submission, a process with these features was unfair in every case. It was a timetable so short, it prevented any proper investigation or gathering of evidence. It deprived individuals of the far more extensive opportunity they had under the principal rules to prepare their appeal. And on top of that, it severely limited the first tier tribunal's ordinary case management powers to relax the timetable. And furthermore, it did so at the defendant's behest, without any consideration of whether it was fair. Now, the only contemporaneous justification for this extraordinary scheme was the rules themselves. But those rules have been quashed. And in their absence, in my submission, it is not possible to justify that allocation. Now, it was so unfair, my lords, my lady, at paragraph 34 of our submissions, and this is supplementary bundle electronic folder 71, we set out the views of the Tribunal Procedure Committee about them. They said that that period, of the longer period that was being suggested under the 2014 rules, that it was wholly insufficient as a rule for an appellant to consider the Home Office decision, collate any necessary materials and prepare a case to present it to the tribunal. And it's why the Tribunal Procedure Committee's understanding was that immigration judges would not, if given discretion, which of course they didn't have under this scheme, replicate the current regime because of the risk of injustice. And the underlying materials for that summary at paragraph 34 of our submissions, the references are in our submissions. Now, it's these features of the system which the High Court in DA5 described in every case as a serious procedural disadvantage, which comes from the abbreviated timetable and curtailed case management powers. And it's also these features which led the Court of Appeal to conclude not that there was a risk of an unfair hearing, but that it was impossible for there to be a fair hearing of appeals in a significant number of cases. And you've been shown those paragraphs. But rather than consider whether the appeals were unfair by virtue of these features which were generic to all of them, both the High Court and the Court of Appeal stated that there would have to be some basis for holding the decision was unfair beyond that it was reached under the first fast track rules, and that unfairness would have to be evidenced by reference to disadvantages specific to the case. In my submission, that approach was wrong. As already indicated, it wrongly assumed that a majority of appeals could have been considered fairly, despite the findings in DA5 and DA6. Secondly, it suggested that generic features alone could not render the process unfair in individual cases, only disadvantages specific to the case. And thirdly, and this is a point that my learned friend Ms. Harrison was describing just now, by insisting that the process would only be unfair if the generic features caused unfairness in the particular case, it confused the fairness of the process with how an individual may avail himself of that fair process. And the Supreme Court in Pathan has made clear the importance of strict segregation between the two in paragraph 140 of that judgment. So turning to the findings in DA5, I just want to highlight a couple of aspects of that. The court's conclusion that the majority of cases could have been decided fairly in TN seems to have derived from the jurisdiction for a finding of systemic unfairness. Because the jurisdiction is, the threshold is unacceptable risk of unfairness, the court seems to have concluded that it follows that the conclusion in DA6 does not entail the necessary conclusion that in each and every case a particular decision was itself unfair. But in my submission, it's important to look at what the courts actually said. And the starting point for understanding DA6 is Mr. Justice Nichol's judgment, which was upheld. That judgment is in the authorities bundle at 2291, tab 4. And if I could ask you to look at paragraphs 57 to 60, you will see that Mr. Justice Nichol puts it this way: in my judgment, the fast track rules.
Which page, please?
It's 2291 is where the authority begins.
Don't think so. DA5.
DA5. I do. DA5. Sorry, it begins at 2273, and the 57 is at 2291.
Thank you. Thank you.
So in my judgment, and this is paragraph 57, the fast track rules do incorporate structural unfairness. They put the appellant at a serious procedural disadvantage. And then at paragraph 60, further down, again, the procedural, what seems to me to make the FTR structurally unfair is the serious procedural disadvantage, which comes from the abbreviated timetable and curtailed case management powers, together with the imposition of this disadvantage on the appellant by the respondent to the appeal. My Lords, Mr. Justice Nichol concluded that the procedure was unfair for everybody who went through it. And that judgment was upheld by the Court of Appeal in DA6. It's right that at paragraph 27, the Court of Appeal of that judgment, and that's on the following paragraph 27 is at page 2307 of the electronic folder. It's right that the Court of Appeal set out the test and the threshold, emphasising that it is a high threshold, but that the highest standards of fairness apply in asylum appeals. But the actual conclusions go beyond the threshold. So you'll see in the paragraph that you've already been referred to this morning at paragraph 37, that Lord Dyson described the unfairness as being inherent in a system which requires asylum seekers to prepare and present their appeals within 7 days of the decisions which they seek to challenge. In my submission, that is a conclusion that applies across the board. And he then goes on in the paragraphs that you've already been referred to, at paragraphs 38, 43, and 45, to describe the unfairness as inevitable, as bound to arise, and to make it impossible for there to be a fair hearing of appeals in a significant number of cases. Now, that is strong language in my submission. And in my submission, if it's impossible for there to be a fair hearing in a significant number of cases, that is a strong indication of the high risk in all of the cases. And that is why when the Court of Appeal talks about what the Tribunal Procedure Committee might do to correct the unlawfulness, and that's at paragraph 45, it says, and Lord Dyson says, it seems to me that some relaxation of the time limits is necessary. He doesn't say in some cases, he says that is across the board. And similarly, at paragraph 48, and if I could ask you to have a look at that, it's at 2312 of the electronic folder. When he's considering Mr. Justice Nichols' reliance on the fact that the defendant put individuals into the process as an aspect of the unfairness, he says, it is sufficient for me to say that if, contrary to my view, the rules themselves are procedurally fair and enable an appellant to present his appeal fairly and justice to be achieved, then I do not consider that the fact the appellant is in the fast track system as a result of the decision of the Secretary of State is relevant. So he's saying that they don't. It's his view, based on that paragraph, that these rules do not enable an appellant to present his appeal fairly and justice to be achieved. They don't give that opportunity in the language of pattern.
Say about the case, could I just ask you, what do you say about the case? Well, I suppose there are two. Firstly, where the appellant comes along and says, I know all the information, I don't want to put in any more. And you've got to assume for the purposes of this question that was a proper consent. And he has his case heard. Is he entitled to have it set aside automatically? And then there's the other case where somebody comes along and is able to discharge the burden on him or her within the fast track procedure. And the question would then be whether the decision in his favour would be automatically to be set aside. Because that's the logical conclusion of your argument, I think, unless I misunderstood it. Forgive me.
Well, my lady, I think what you're asking me in the second example is if the appellant succeeds in the appeal.
Mm-hmm.
But the appellant, as Lord Panic described this morning, would not seek to set it aside in that situation. If
Yes,
he's managed to...
But your proposition is that it's automatically set aside. And I'm not asking you to undermine Lord Panic's submissions anyway, but I'm left with this problem that the successful cases also get set aside, as well as the one where somebody has deliberately given up their rights to object.
Well, my lady, I have deliberately not used the language of automaticity, and in fact, I don't believe that Lord Panic used it this morning. The question is, what I have said is that these features, when present in these appeals, mean that each and every case was determined unfairly. Now, obviously, if you succeed, you are not going to seek to set your appeal aside, and you're not going to be arguing that the unfairness had any consequence of note. But if you lose, as most of these appeals did, the failure rate was exceptionally high in this jurisdiction. If you lose, then you have a basis based on the aspects of the appeals that I have described for saying that they were a strong basis for saying that they were unfair. They were unfair. It simply was unfair to deprive these individuals of the opportunity that they would have had under the principal rules, but for this ultra vires and structurally unfair process. So I think that's answering your, yes, my Lord Stevens.
Well, to my mind, that is an automatic setting aside of the rulings, only requiring an application to be made. And it is still automatic. As soon as you make an application, the ruling is set aside. And I don't think as yet you've answered my lady's first proposition, and that is where somebody does have an opportunity and does present their case properly.
Well, my Lord and my lady, I was about to come to the first question. The issue is you have to assess and this is where I was going to come on to Patan, but you've heard submissions about that this morning and this afternoon. You have to assess the question of fairness at the point that the decision was made to allocate the appeal to the process. That is the point at which the question is assessed. And Patan makes that abundantly clear.
So that is an automatic. That is an automatic setting aside of all decisions, because
well, my Lord,
necessarily.
Yes. My Lord, I don't accept that is automatic in the sense that it automatically follows by operation of some rule of law. What I'm submitting is that it is an inevitable consequence of the features of this scheme, which I have described, that these appeals were determined unfairly. Now, the result of that is that individuals will be able to apply and say, my appeal was determined under this scheme, and therefore I should have it quashed or set aside. I accept that that is the consequence of the submission that I'm making, but it is the result of the features of the scheme that were present in every case, which in my submission were unfair. And they have to be assessed at the start when the decision was made to allocate an individual to that process, or in this case, lack of decision, because the FTT never considered it. That is the point at which the question of fairness has to be assessed. So, my Lord, but the Court of Appeal in TN did not take that approach. They insisted that there must be features specific to the individual case. And in my submission, it simply does not follow that it does not follow necessarily from the fact that a finding of systemic unfairness would not lead automatically to the setting aside of the decisions. It does not follow that it's necessary to look at the facts of individual cases to decide whether each and every one of them was unfair on those specific facts. If it did, the Court of Appeal in DA6 could not have concluded, based solely on the generic features that I've described, that it was impossible for there to be a fair hearing of the appeal in a significant number of cases. That was a conclusion that was based on the generic aspects of the scheme. So in my submission, there is a prime question which must be answered before looking at individual facts. And it's the question that I've sought to answer this morning. Do the generic features of the scheme mean that there was unlawfulness in each and every case? And so it was wrong in my submission for the Court of Appeal to preclude individuals from relying it, and that they did by insisting on disadvantages over and above inclusion in the fast track rules. The court should have asked whether an appeals process with the features I've described could ever have been fair in any appeal, and if so, in what circumstances. And only after that consideration, within the framework identified, might the facts of the individual case be relevant. And that is where, in my submission, Patan comes in, because according to Lord Justice Singh and Mr. Justice Ousley in the Court of Appeal and the High Court respectively, in order for there to be a finding of unfairness, there had to be evidence that the fast track rules caused unfairness, which the principal rules would have avoided. But in my submission, they plainly did cause unfairness because they were procedurally unfair for the reasons I've described. So that approach turns out to mean to result in the exercise which Patan has confirmed in my respectful submission, has confirmed is impermissible, which is to examine whether the procedure would have made a difference to what the appellant would have done, such as whether fresh evidence would have been submitted, or whether vulnerability would have been raised or was raised. And it also assesses fairness by reference to how the appellant reacted to the unfair system, where applications for adjournment or transfer made out at the time. But that's not the right approach. It doesn't observe the strict segregation required. It also has the effect of placing the burden on the appellant to show unfairness, when in fact the proper question the court should be asking is, was the decision taken by the first tier tribunal fair and lawful? That is the decision that is supposed to be being assessed, the decision to allocate an individual to an appeal, not how the appellant reacted or engaged with a system which has now been found to be structurally unfair and ultra vires. So applying the right approach, the fairness of the procedure is not to be judged on an ex post facto basis, and an asylum appellant should be afforded as much opportunity as reasonably possible. That was the principal rules, to deal with a decision which potentially has devastating consequences. That's pattern, paragraph 107. And you've heard about that it's not necessary to rely on the estimate of likely success in pursuing the chances that opened up for them. The cornerstone, says Patten at paragraph 132, is procedural fairness. What was the fair thing to do procedurally? It's all about a loss of opportunity and a loss of chance. And inescapably, in my submission, every appellant who has entered into this process lost at that opportunity. And it's not the question of whether they would have availed themselves of it is a separate question and an impermissible one. It's whether there was a fair opportunity. So for all those reasons, we say, I say on behalf of the joint interveners, that the court got it wrong on grounds 1 and 2. Each and every decision was unfair. Alternatively, it is clear that the majority were unfair, and only in the most exceptional cases could it be said that there had been a fair decision. Turning briefly to ground 3 before I close, the joint interveners also submit that the court erred in its approach to assessing fairness on the facts of Tien's case. And the joint interveners are particularly concerned about the court's failure to recognise the potential impact of trafficking on the fairness of an appeal. And our submissions on that are set out in detail in the written submissions. But I want to just highlight 2 points before I stop looking at the time. And the first is that the court relied for its conclusion on fairness on the fact that Tien did not self-identify as a trafficking victim in the UK while in the fast-track system, even though she was able to mention other traumatic experiences. But my lords, that conclusion goes directly contrary to several judgments of the UK courts, but also to the judgments of the European Court of Human Rights on obligations under Article 4. Self-identification is not required to trigger state obligations. And you can see that from our submissions at paragraphs 59 to 60, electronic folder, page 82. And there are good reasons why self-identification is not required. That is, as Ms. Harrison explained earlier on, is because it's accepted that trafficking victims are often severely handicapped in self-identifying. And the fast-track process exacerbated those obstacles that trafficking victims face. Finally, and particularly concerning, is the Court of Appeal's conclusion, and this is at paragraph 147, that the process was fair because the reason Tien gave for not adducing evidence was threats from her traffickers rather than the shortened timetable. The possibility that traffickers retain influence over their victims is one of the reasons why a shortened timetable is so inappropriate, because it impedes the disclosures to responsible professionals, which may permit the individual to extricate herself or himself from their control. So a trafficking victim's or potential trafficking victim's inability to produce evidence is due to the shortened timetable, because it diminishes the chance of building the necessary relationships of trust, and that the deprivation of that opportunity, as Patan confirms, is itself unfair. So, my lords, looking at the time, I refer obviously to the much longer written submissions that we have made and the references that are contained. Unless there are any questions that your ladyship would like to ask me.
It appears not, Ms. Kilroy. Thank you very much. As you say, we do have your detailed written submissions, for which we're grateful. We have those very much in mind. But thank you for your oral submissions as well. So it's now time to stop for today. We'll resume tomorrow morning at 10:30 when we'll hear from Mr. Tam. Hearing's now adjourned. Thank you all very much.